Welcome, everybody. We're to this episode of the Justice Team podcast. I almost said good morning. It's afternoon when we're recording this, but it's not live, so I guess it could be good morning to whoever's watching it in the future. So we have a panel today. We're going to be talking about juries and trials during and after COVID and how it's impacted our industry and how it's impacted people's personalities and kind of trends we're seeing from our juries, seeing how they've used kind of their experiences with the pandemic and kind of changed their personalities. So we're gonna go around and do some introductions. So Bernard, if you want to introduce yourself, you're new to the Justice Team podcast. We've never had you on before. So if you could say hello and introduce yourself, tell us a little bit about your firm and your long tenure as a fantastic trial attorney and employment attorney. Take it away.
Thank you very much. My name is Bernard Alexander. Our firm is Alexander, Morrison and Fair. The firm, in one iteration or another, has been around for about, we're coming up on 15 years. We do plaintiff employment law and civil rights. The employment is probably 80%, civil rights is 20%. I've tried probably 70 cases by now, but I say 60 so I don't have to, over 60 so I don't have to count them. I typically try, at least 2 cases a year, some cases more or less, and I've had verdicts ranging from, 5 million, 10 million to now 137, and I hope I haven't peaked too soon. I created the trial college for the California Employment Lawyers Association, CELA, and I've been instrumental in creating, or at least managing the boot camp for the National Employment Lawyers Association. So I've done a lot of training of people with regard to trials and the subject matter we're talking about today, jury selection.
All right. Well, excellent. Thanks for coming on. We really appreciate it. Harry, Claire, if you guys want to, I don't know how you usually introduce. Do you introduce one another? Is that how you usually do it?
Harry, you can introduce yourself. I don't care. Go ahead.
Well, first I was interested by this boot camp thing that Bernard was talking about. What is the legal equivalent of a burpee for lawyers when you do boot camp? Maybe we'll think about that and talk about it. But happy to be here.
He is picking the jury, and since I've used Harry as a jury consultant, and I've just waited for Harry to get sick for a moment so I could use Claire. I've talked to Claire about being a jury consultant and people that she's consulted with, and they are just fantastic in terms of being resources.
Everyone's been waiting for me for the last couple of years to get COVID, not just you, Bernard. But I'm still holding out so far. But thanks so much. Claire and I are jury consultants. We work, for consumer cases, injury cases, and employment cases only on the plaintiff side. And that's like 99% of our work. Once in a while, we'll do a boring commercial case or a patent case. When it's a business suing a business, I don't really care what side we're on, but only plaintiff on this side. And so, we both work on different cases. We don't necessarily work on the same cases together, but we both, work on different cases, picking juries, doing focus groups, giving advice to lawyers on how best to present their case. And our big thing these days is nuclear verdicts. My favorite topic to talk about. Brandon had asked, are you sick of talking about post-COVID juries? But hopefully I'll just be talking the next 10 years about nuclear verdicts and Armageddon verdicts. Technically, the Tesla verdict that Bernard and I worked on was an Armageddon verdict of over 100 million. So hopefully there'll be the next level beyond Armageddon. But Claire, go ahead.
Yeah, I was going to bring up your verdict with Bernard if you weren't going to nicely pat you on the back. But I do, just like Harry said, I work with him occasionally on the same cases, but usually I do my own. And it's not 137 million, but I did have the highest verdict in the Burbank courthouse, July of 2021. So post-COVID verdict of 21 million for a wrongful death in a case that I actually told Harry when I went to pick the jury that I think there's a 90% chance we're going to lose. So I'm just going to hope for the best and pick a good jury. And then
it was a tough liability case against Caltrans against the state of California. Yeah, for sure. In a case with a guy who was, it sounded like he was driving at 2:30 in the morning on a freeway and lost control of his car by himself. there's a whole, so it was a tough case. Yeah.
I mean, I think Harry would have defended the case. Harry's like, but he yeah. And I think I picked the first case against Lyft just this last fall. I think that might be the official first, at least in California, first verdict against Lyft. So
Burbank,
it was not 137 million, but it was pretty good. Yeah. No, Burbank, 21 million, I was thrilled with. Yeah.
21 million is 40 million in Burbank. That's a tough conservative jurisdiction.
It was Bernard, you would have loved that jury. It was a good jury.
I love every jury.
Yeah.
It's whether they love me back.
We have Jason Sanchez, who's one of our resident trial attorneys. Jason, you want to introduce yourself?
Yeah, sure. Jason Sanchez, the Simon Law Group, joined SLG in August of 2021. Had the distinct privilege of being a part of 3 trial teams since August, all with verdicts for plaintiffs. And it's been a great experience and an eye-opening experience, too, as it relates to picking a jury these days.
So, yeah, a lot of ground to cover, a lot of people with a lot of experience, both before and after COVID. But Harry, Claire, what you guys are involved in picking a lot of juries. What are you seeing? What's different now, both in terms of physical difference, masks and communicating, and also are people different? Are we changed by this, and are we taking it out on our verdicts?
Harry, go ahead.
You want me to go first? I think the thinking right after COVID hit, when trials were shut down everywhere and they were about to come back and people were wondering what was going to be different, I think the first thought people had was that the makeup of the jury is going to be different. And that might be true to a little bit of a degree, but for the most part, the juries that I picked, it's not like the makeup is really that different. There's older jurors coming, there's younger jurors coming. Some people thought the all the liberal jurors wouldn't show up because they'd be nervous, and all the conservative jurors would show up because they didn't care. And then some people thought the other way. Well, if there's a mask mandate, because pretty much I think every jury I picked, the jurors have had to wear masks so far, and usually the lawyers too, even during voir dire and opening statement. There've been a few when they're allowed to take it off, from the podium. But then there was thinking, well, maybe the conservative jurors won't show up because they don't want to wear a mask all day and they don't want to comply. From what I've seen, it's pretty much very similar. There might be a little bit of some groups not showing up, but it's pretty much, you get people from all walks of life. I think the main difference is that jurors, the last couple of years have gotten a lot more raw emotionally. I think they appreciate and don't take for granted things like quality of life and health and people being alive. I think that people, from what I've seen, are a lot more fed up with, BS excuses. There's a lot more distrust of companies and how they conduct themselves. I don't know if that's so much from, people being pissed off or just looking for an outlet to be pissed off because of COVID, or if there's been things that they've seen companies do in the last couple of years that they're just not happy with. I feel like it was starting before COVID slowly, and COVID has just accelerated it. But, I've just noticed a lot of, just a lot more outrage toward companies and a lot more jurors getting pissed off and polarized when the defense lawyers come in and kind of make excuses that don't fly. Bernard's Tesla case was a great example of that, where jurors just got super pissed off by things that, 5 years ago, they might not have been that angry about. And they were especially angry that Tesla, in that case, there was a lot of issues in the case, but one of them was Tesla was saying, we're not even this guy's employer, so we're not even responsible for what goes on in the workplace, even though it was a Tesla factory. They had a legitimate, affirmative defense saying we're not his employer, therefore we're not responsible. But what the jurors heard were, we refuse to take responsibility for our workplace, and it just pissed them off, 10 times worse.
I agree with you. I would make the caveat, though, that just because they're angry at corporations doesn't mean angry jurors are good for you. I would still argue that in a voir dire, if there's a ton of angry jurors, you still don't want them. You know what I mean? If they're angry about being at jury selection. And the reason why I bring that up is I have seen, Harry and I have discussed this, I have seen some waves during the pandemic of where jurors kind of got bad again. Like, I feel like Harry and I both had very good verdicts in, I think it was about July of 2021. And I think it had something to do with being out in social again and not being worried about getting COVID because everybody had been newly vaccinated. And I think people were just really excited and happy to be there. I mean, the Judge Stewart in Burbank commented on how it was the most talkative voir dire he'd ever seen, because people were just so excited to have someone to listen to them. But then I feel like there was a little bit of going the other way in January of this year or December of last year, when people were worried about Omicron, and then people got scared again and didn't want to be there. So I think it's kind of, it is fluctuate based on how scared people are of COVID. Because, I don't want jurors who don't want to be there, or if they think they're going to, give their kids COVID by being there or whatever. That's a tough one that we've had to navigate a little bit.
Yeah, I think that's when I talk to most trial attorneys, that's what they say. Picking a jury is, regardless of when it's happening, COVID, pre-COVID, post-COVID, is you want people who want to be there. And it's hard to do when there's a airborne virus that's super contagious that nobody wants to catch.
In that vein, I think it is possible, especially during like Omicron, where the hysteria was pretty high, like early January. I definitely think there's something to be said for some of the perhaps more cautious people getting off. That's probably true, right? I mean, but the people who came with like gloves and stuff, they all got off, So if you were to say that those people might give higher verdicts, which I don't know, I mean, it may be that it's possible that that edge was lopped off,
Bernard, what I mean, you had obviously the massive verdict against Tesla. What has it been like representing employees during this phase of our, history with workplace safety and people not necessarily being able to work because of the current situation we're in? What was that like? And what is it like representing employees in a COVID world?
Well, it's interesting. I'm going to say for a number of reasons. So I had 2 trials last year, and the first I lost, and it was in front of Judge Zulliger in Long Cause in Los Angeles. And the main difference, and one of the reasons I thought we lost, was really because my client was an attorney and did not make a good witness on the witness stand. But the jurors, in terms of the jury itself, I actually liked the jurors, and we were spread out. So in terms of picking the jury, it's generally nice to have juries inside the box, because you get this popcorn effect where one person said something and it kind of spreads among the jurors, good and bad, and you can find out information from other jurors based on their reaction to the jury you're talking to. So you get that ability. Inside of Judge Zulliger's courtroom, they were spread out. I think 5 were in the box, and the rest were in the audience area spread out. And so you didn't have that ability to have that interaction that you normally have, even non-verbally. So that was an oddity. Then you add everyone's wearing a mask. You get a lot of cues from people from wearing masks, and the inability to be able to see their faces. You can just see their eyes, and sometimes they dart or that. And so you're so limited in the feedback that you get. So that's one of the things. So we had the Judge Zulliger effect. Different effect in federal court. In federal court, by the time of October, the court was allowing people to sit in the vicinity of each other, although they were spread out inside the courtroom. But you still got more of a feel. It was more, as opposed to in a tight box, it was more like in a church where you see a choir. People were kind of spread out, but you could still get a wave of people. You could still get people reacting to each other. So, there are consequences to the way judges kind of set up the courtroom in reaction to the circumstances. But the thing that, in terms of the people that we're getting, I think the time people sitting alone, being forced to watch television, being forced to see what's going on in the world, and not having the ability to communicate with people in person, I think we have that dynamic that we're dealing with when we're dealing with jurors. The Black Lives Matter is occurring during that. People being this kind of confirmation. People might have thought, maybe this doesn't really occur, but now it occurs. And if it can occur in that aspect, remember, we're dealing with a race discrimination case with regard to the Tesla matter, and we're dealing with race issues with regard to Black Lives Matters. So I think people being forced at home to see current events and see that this could happen, and then seeing it happen in the workplace, a different form of race discrimination, I think that had some some effect and some effect.
Yeah, that's. I guess this pandemic's been going on for long enough now. I guess you kind of forget the things that have occurred while we're under not a lockdown, but while we're in pandemic. I mean, I kind of forgot that a lot of the Black Lives Movement matter really took off recently with George Floyd and the riots. That was during COVID, and so you make a good point. People are home and we're watching TV more, and maybe we are socially more aware because of that. Maybe it's just the natural progression of our psyche and human beings. But that's an interesting point that people are stuck at home watching TV, and that's what we see. And hey, maybe we're paying attention to this stuff more. It's a good point. Jason, you've tried. Oh, sorry, go ahead, Eric.
Yeah, so people I think have more time for Twitter than they used to thanks to COVID. I know that your brother Bob always has time for social media, but for the rest of us, we actually have more time for it. So that's always nice. Go ahead, Jason.
Jason, you've tried 3 cases during COVID since you came to us. What's been were they all different venues or were they all the same venue?
The first one was actually downtown LA. The other 2 were actually Van Nuys, and they were almost a month apart. Van Nuys in October, Van Nuys in November. And it was an interesting experience because the LA one was August and it was downtown LA. And so everybody was in the box and there was no social distancing. October Van Nuys, everybody was spread out. You had people in the box, you had people behind you, much like what Bernard was saying. And so during jury selection, it was hard to read everybody because you're looking behind you and you can't see how the people in the box are reacting to what's being said. That was an interesting experience. But I would also echo what Claire said too. I think that people were cooped up for so long, they were almost longing to talk to other people. And it also helped juries kind of coalesce. They grouped up faster, and you could see different factions developing as the trial goes on. So that was an interesting experience too.
I would say and this is not really a juror attitude, but it's been a negative side effect I've seen of COVID juries in the last year. Maybe I've been unlucky, but I feel like because of the distancing and the nature of having so many jurors in a courtroom and the judge trying to bend over backwards for jurors' convenience, I've been forced to do a lot of jury selections with horrific time limits with a lot of jurors all at once. And, let's do 30 in 30 minutes, that kind of thing. And I've had that happen. I mean, easily 5 of my 20 juries in 2021 easily were like that. And that's very hard to pick a good jury.
Yeah, you talk about jury anxiety, but judges are kind of anxious, and a lot of them are wanting to just, especially jury selection, to speed it along, get it done, as quickly as possible, because that's the only time when they're really worried, where they have a ton of people in the courtroom, and so they're probably wanting to clear that out as quick as they can. So, but one thing I found that makes a huge difference we've been talking about, and maybe I'm sure Jason, I'm sure you saw this. I'm curious to hear your thoughts too. Is that, and this is not, especially during COVID, but even before COVID and after COVID, it's long gone, hopefully. When there's a big difference between a judge who is lenient on hardships and one who is really strict on hardships. We on the plaintiff side, we love it when judges are super lenient and get rid of everyone who doesn't want to be there. And the people are there. Nobody's pissed off. They're all at least okay being there. But for those judges who make it really strict and you get a bunch of people in the box who are pissed off to begin with, that makes a huge difference. You got to use a lot more strikes on those folks, and just totally changes the tone of everybody. Jason, did you have differences for you in judges letting people go or not? 3
very different experiences. The first one in LA was very methodical, and we spent 2 days just trying to qualify people for hardships. The second one, the judge was very much of the opinion that if they didn't want to be there, or if they had a slight problem being there, the judge didn't want them there to begin with, and they were gone. The third judge was like, all right, plaintiff's counsel and defense counsel, here's the hardship questionnaires, you guys figure it out. And then what you can't agree on, I'll then decide. And so it was a really interesting experience.
Well, I think it's really impressive that you got verdicts in Van Nuys, because Van Nuys is also a very tough venue. There are different venues for different reasons. It's not just the neighborhood you draw from, but it's kind of a resistance that you get. And so when Harry's talking about conservative judges, it's one thing if the judge is lenient in letting people go, but he also gives you time to do voir dire. But if they give you 30 minutes to pick the jury and then they give you limited time to do the voir dire, that just ruins the whole process, because you don't have to get jurors that are on your side, but you need to get jurors that are receptive. And if you can just have the time to get receptive jurors, then you can get through the trial. But to rush that part of the trial as opposed to other things, I'd rather them put me on a time schedule, tell me this is how much time you get, but give me the time to pick a good jury, because it does no good to throw pearls to swine. You got to have receptive jurors in order to have a shot at winning, and certainly if you're the underdog, right? And certainly if you're in Van Nuys or Burbank, where they don't want to give away money.
Especially with masks too. The one thing I found and that we realized in the first couple jury selections that we did after COVID was, we rely so much on, a juror talking and looking around and seeing who's kind of nodding their heads, or who's got a big smile on their face, or who's got a sour expression on their face, or whatever, who's rolling their eyes. Like you lose a lot of that. And so one of the things we found out is you have to ask a lot more open-ended questions and get the jurors talking. And you got to make sure to ask one-on-one questions to everybody, because it's so easy with masks and a spread out courtroom to realize when you're done with your voir dire and you're picking the jury to go, oh my gosh, we didn't talk to these four folks, who are in the back corner, and we don't know anything about them. I didn't even see if that person was even smiling or not. I didn't get anything on them. So during COVID with masks on, it takes more time to pick a jury, I think, in voir dire everybody. And so when you have a restriction, it's just really tough to do it. But you got to make sure you do, even if you get 30 minutes, you got to make sure you get at least one question for every person, and make sure
I had a restriction in Orange County just, a month ago. And I told Harry, luckily I got enough cause challenges that I used a strike on somebody who didn't really even say anything all that bad. But I just got a sense that underneath his mask, he was smirking. And it's silly to say that, but in a real jury selection pre-COVID, I did rely on smirking. There's like a very standard juror that I can pick up from a mile away who it wants nothing to do with your case, because, they think they're better than it or whatever. And you can tell from the look on their face. But yeah, if you don't have cause challenges or you don't have enough time, then you don't get that gut reaction. So I was just lucky there. And I felt kind of bad. I told the lawyer, I'm just going off a gut instinct here, but I just really think he's smirking. But I can't confirm it.
But the smirk is a big deal, because I always tell my clients, look, I'm going to get a vibe from the jury, but I need you to be looking at the jury. And if you get a vibe from one of them where they don't like you, and you got to let me know. And the fact that people can't have their masks off, because, it's like you walk into a party. People are repelled sometimes, they're repelled by the story. They're repelled by some way that your client looks. And that's enough, right? But if you don't get to see that, that's, because I've done the same thing on a hunch, because that person, I just don't like the way they're looking. I don't like, and that is enough. That's what jury selection is supposed to be about. And you miss that.
I actually had a trial in Santa Monica in October where the plaintiff attorney made the choice to have all of his witnesses, including his client, present on Zoom, because he really didn't want his client to be masked, because he'd had a TBI. And he really thought it was important for the jury to see his face. And we'll never know whether or not it was a good choice, but it was $2 million verdict. So,
yeah. In federal court, our judge, once you got onto the witness stand, or once you were asking questions of witnesses, then the attorneys could take off their mask. The witness got a choice as to whether they took their mask off or not. So they did get to see them. But that's a big trade-off. They can see my client's whole mask, but they're on television like it's not real, or they're inside the courtroom with the mask. I'm not sure which one. That's a tough choice.
It's a really tough one. It worked out, but I don't know if I'd recommend it for everybody.
Harry, Claire, do you guys find that the jurors actually pay more attention because witnesses or the attorneys are actually wearing masks, so they have to listen more, or not?
I don't know. That's a good question. I don't know. I would guess that they are from what I've heard, sometimes they're frustrated by struggling to hear quite as well. So maybe subconsciously they're trying a little harder. But I don't think that they're necessarily paying more attention than they were. But I think they are frustrated that they're not getting a lot of when a witness does have a mask on, they're not getting a lot of the same way that they would read somebody's credibility. I have heard jurors be frustrated about that, especially the ones who were like early on, who were like, if they spread out the jurors. I heard a couple cases where they were like way in the back of the audience because they're so spread out, and they were going, can't even see the witness, especially with a mask on, 50 feet away. So it's frustrating for them.
In my trial in February, the jurors in the back relied on a juror that was sitting closest to my client on the witness stand, who said that my client, before he'd answer, would look up and kind of roll his eyes. And that made her believe that he wasn't being truthful because he's got the mask on and he looks like he's robbing a bank. She didn't say that part, but that's my interpretation. So, so basically the determination of the credibility of my client was the lady sitting in the front. She made the entire determination for the entire jury. It's the only trial where I picked the foreperson. I picked the person who turned out to be the foreperson. She was on my side, and I lost. She couldn't convince others. That's never happened to me.
In terms of, these are all great stories and difficulties picking a jury. But in terms of, are you finding after, because obviously we're allowed to speak to the jury after we get a verdict, ask them, what they thought about this. Or, Harry, have you found it? I know you've talked about this before because I've heard you talk about this before. But I know in our firm internally, we had, fears that coming out of COVID and doing verdicts again, people were going to be stingy with money and they were going to say, I've gone through this, tough shit, pick it up and deal with it like I did. But by and large, at least, in our firm, and I think you have found quite the opposite has happened.
Exactly. Yeah, that was the fear for sure, that people would say, I've seen, it's a wrongful death case, and I've seen so many people have lost loved ones to COVID, or, or some people have lost their jobs, or, the employment case. So what, everybody's going through the same thing, buddy, suck it up. But it's exactly been the opposite. I think people are just more appreciative of health and quality of life. I think they're more appreciative of a job, and they're kind of blaming, rather than kind of saying suck it up. They're kind of blaming whoever caused the harm, or in employment cases, employers that weren't responsible. They're kind of blaming them for it. I think it's kind of like the same thing with people who, what is it called, the great resignation or whatever. Like, people are expecting kind of better out of life after the last couple of years. And so people's standards are up despite the fact that it's been tough. And I think that's a great thing for us, is that they're kind of saying, no, I expect better of companies. I expect better of employers. I expect, I'm expecting, I know for me, the next couple of years better be great. And I'm going to get pissed off if somebody, if I hear somebody's has an injury that basically puts them back, in lockdown mode for the rest of their life.
I will add, though, I feel like that is definitely the case if your defendant is a business. I feel like I've had a couple verdicts that were sort of uncharacteristically low for me against an individual, like a car accident where it's like one person against one person. And that being said, both of them were very limited voir dire. So perhaps it could have been fleshed out better with how people feel about an individual defendant. But I felt like maybe COVID made people a little more sensitive to another person's individual financial hardship, perhaps for those people who aren't fully aware that insurance is just paying for it, but they think it's coming out of that individual's pocket. I definitely felt like I had one defendant who was just a really nice, young African-American guy. And I think the jury was like, come on, we're not going to award a ton of money against him, So
you got to get juror declarations saying that they felt sympathy for the party, and yeah, that's interesting.
And you got to polarize the case. Obviously, a case against an individual driver, especially if they admit liability, is a lot tougher to get jurors angry. But I think you always, on the plaintiff side, always have to find a way to work in some kind of betrayal to polarize the jurors. So even if it's individual.
A good point about someone not being able to work. That was before COVID. We kind of built in our general damages stories through that. People's livelihoods. A lot of people really take pride in what they do, even if it's a blue collar job that's not that glorifying. People take pride in being able to go out and do a construction job 10 hours a day and put food. You take that away from people. And now people probably, and Bernard, you can probably speak to this as an employment attorney, people probably resonate with that more now, that people, hey, I lost my job because of COVID or whatever. So that's an interesting take.
Well, I think that coming back after COVID, people who have wanted to be in their jobs, who see someone that's trying to be in their jobs and has it taken away, I think that has an impact. It's in employment law. I think we always have an advantage because the people on the jury are generally employees, and there's some way to have a connection. I mean, I'd always tell people, for me, the real point of doing the jury voir dire is to find out who the jurors are, so I can find the story that my client can tell, because there's lots of pieces of it, so it can echo the people inside the jury. And, goes back to the point that Claire was making, to not have time to spend time with the jury, you really don't know who your audience is, so you can actually, talk to them so that you can echo what they've experienced, because that's how I get damages. They're upset because this could have happened to them, and it's some version of an experience that has happened to them, right?
I will tell you one takeaway I had from the Lyft trial, because we did questionnaires, and granted it's Sacramento, which might be a slightly better venue than, I'm sure it's better than Van Nuys, but I was shocked. We had a vicarious liability question, on the questionnaire, what do you think about holding an employer responsible for the actions of his employees? And the answers were awesome. I think 90% of the jurors thought it was important, that it was necessary, and they talked a lot about employer negligence, and how and you need to hold employers responsible, or else they'll take advantage. And so I thought that was a different, maybe that we wouldn't have seen that 3 years ago, or I just got a really lucky panel. But
that's definitely a sign of the times. I think that's something that you wouldn't have seen. You would have seen at least half of the jurors before saying, why are you holding a company responsible for what one of their drivers runs a red light or does something bad. And, it's kind of the same thing. When I was picking a jury, I don't know when it was like in the summer, with Gary Dordick. It was an interesting case, admitted liability case against the city of Beverly Hills, and Beverly Hills Police Department had caused a crash and were admitting fault in the crash. And you'd be shocked at the number of jurors that we had to battle it and lost for cause, because so many of them. And I'm talking about, I'm just thinking, anecdotally, like I remember there was types of jurors you never would have thought would be anti-police. I remember there was like an Asian American doctor who worked at Kaiser. There was like this white older white guy who was like a CFO of a startup or something like that. And they were like, I'm sorry, I'm biased against the police and the black, I'm pro Black Lives Matter and all these things. And I was like, this is just a sign of the times. This is ultimately, it was bad for us that we were struggling to keep any of these folks, and we're losing a ton of jurors, but which comes into play, which prehabbing your jurors, by the way, is incredibly important, and convincing those jurors that they can be fair as long as they can just judge, wait to the evidence to decide the case. Number one thing, by the way, that's so important to tell your jurors in the start of voir dire is you are allowed to get angry if the evidence makes you angry. You're allowed to feel sympathy in this case, because the defense will get up there. They always trick the jurors and saying sympathy has no place in here and you can't prejudge the case. But you tell them those things. You're allowed to, as long as it's the evidence. Anyway, but I was just shocked. The number of people that 5 years ago would have been like, I don't really like lawsuits, and I'm gonna always be for the police. It was like 70% of the jurors. This was downtown LA, but of jurors otherwise who were like, BLM and I don't trust the police, and I can't be fair in this case.
I think you might get different answers in Riverside, San Bernardino than LA, but maybe not. I don't know.
To some degree, but I think it'd be more 50-50 now than like 80-20 against you.
Yeah, and one thing I've noticed, and Harry, I think you might agree, is that I think that COVID and this polarization of the country has made people more entrenched in their beliefs. So I have found that the bad jurors, I feel like I'm getting them off for cause a little easier, because they're just like really angry. And this is where, Harry, the prehabbing is super important, because I don't want to lose my super awesome, great plaintiff jurors. So I have to try to arm them to listen to the evidence, wait to just make their decision, all that kind of stuff. But for the bad people, sounds like you're already leaning towards the defense. Yes, I am. Okay. Definitely, I feel like I've seen a lot of that. People and they're more willing to speak up about it. I don't know if maybe people have been given like an okay to be more candid. I don't know. I feel like brutal honesty is easier now in 2021 than maybe it was in 2018.
You throw a little red meat out for them, and so that you can get them off for cause.
Yep. And cause challenges, especially when you're in a bad venue, cause challenges make all the difference.
Yep.
So, because 6 strikes is not a lot.
No. So, Jason, we talked to you a little bit at the 3 cases that you tried. We talked a little about prehabbing jurors. Before I jump on to Jason, can you kind of explain? I know what rehabbing is. Is this a coin? Is this a coin a term that you've coined? Prehabbing?
It is. Yeah,
it's my Plotkin patent. Yeah,
it is my It's my invention that I've been using more and more. And is the better the case and the better the jurors, the more it's important. It's one of the things that literally every case I think it's important to do now is get up there, and I'll kind of demonstrate how it works. Is we as plaintiff attorneys get to go first, and we get to frame for the jurors what bias is and isn't before the defense gets to get up there and try to convince them that anybody who has feelings or anybody who gets angry doesn't like corporations can't be fair. And of course, we don't get to get up after. We don't ever get to rehab anybody. They get to rehab the jurors that we try to get off for cause, but we don't get a chance to get up again. And so it's so important that we do it up front, and it's a big advantage. But basically what it involves is one of the first things you get up there and you say, you're allowed to get upset. All of you are capable of being fair jurors, even if those of you who've had a negative experience, like let's say, I don't know, throw out a case, Brandon, a type of a defendant that you're suing or anything.
You're asking me to throw out a name?
Yeah, give me any example of like an unpopular defendant or a case or anything like that.
Let's
Kaiser.
say what?
Do it against Kaiser. That's a good one. People
there
Kaiser.
you go. Nobody likes.
Oh yeah, everybody loves Kaiser.
Well, I'm talking the opposite, where you have a problem keeping good jurors. I'm talking about a case where a sex abuse case where everybody gets pissed off and sex abuse,
child abuse or something like that. Yeah.
Right.
Yeah, or could be
Harry, honestly, any kind of wrongful death case. People always have really strong feelings and are sad about it.
Well, I'll give you an example. I'll give you an example of what a jury I picked a few weeks ago that's still in trial, hopefully closing next week, against a nursing home wrongful death case. And you basically say, because there's a ton of jurors, we knew this on the questionnaire, but even without it, there's going to be a ton of jurors who are like, nursing homes are awful. I've had horrible experiences. They're the worst. And you're going to just lose all those people. Every one of those people that you can convince in your voir dire that they can be fair is one strike that you've just taken away from the defense. Because if let's say there's 3 people that the defense knows that they have to strike, and you convince those people that they say, no, I can be fair, and they don't get off for cause, that's 3 strikes they have to burn that they wouldn't have had to burn. So you basically just took away 3 of their 6 strikes. And so the way that you do it is you get up there and you say, I'm sure all of you have had, experiences, good or bad, maybe with nursing homes. Let me pull up my thing so I can tell you exactly. I'm sure you've heard a little bit about what this lawsuit is about. I'm sure many of you have strong feelings about the elderly, about accusations of elder abuse. Some of you may have had elderly loved ones or ones in nursing homes. Some of you may have had good experiences. Some of you may have had bad experiences. None of that makes you unable to be a fair juror. To be a fair juror, all you have to do is let the facts decide for you whether you think, this defendant did something careless and irresponsible in this one situation or not. Does that sound fair? And everyone's kind of going, okay. And you tell them you're allowed to get upset at the evidence if you think a company did something upsetting. Can everyone here wait till you hear the evidence to decide how you feel? And you tell them you're allowed to be angry. Will everyone be allowed be able to let the evidence decide for you if there's something to be angry about and who to be angry at without jumping to conclusions? And when you start saying these things, some of your good jurors who don't like, who really hate corporations or nursing homes or whoever it is, they start kind of nodding their heads and they're like, oh, I totally get it. Because they want to help you, obviously. And I believe you got to go through each one of them. How many of you have ever had a bad experience with the nursing home? And, you get those jurors raising their hands and you got to go through them one at a time. And you say, now has that experience, obviously that wasn't the same as this defendant. No, of course, no, it wasn't. So did that experience convince you that sometimes, not always, but sometimes nursing homes are awful places that do terrible things? And they're like, yeah. And did that experience make you feel like when they do a horrible job, they should be held accountable? And they're like, damn straight. And you're like, great, that's exactly what the law says. Can you, so all I can say is, can you be on the side of the facts in this case? Can you let the evidence decide for you whether you have a reason to be upset at this nursing home or not, regardless of what you've seen before? And they're like, and most of the jurors, you're not going to save everybody, but most of them will be like, yeah, I could do that. Absolutely. And they're like, I'm ready to get pissed off, but I'm going to wait. And then the key question, then you say, if the evidence convinces you that this nursing home wasn't one of the bad ones and they didn't do anything wrong, you're not going to find them guilty anyway, are you? And they're like, of course I wouldn't do that. And you're like, great, that's great. And once you do it with one person, it makes it easier to do it with each successive person. And like I said, you're not going to get everyone. There's some people who don't want to be on there, or some people who are just too honest and they're going to be like, sorry, I'm going to miss. But, if you can get even one of those people, or even better, if you can get 5 or 6 of those people, you just prehabbed them. And when you do that, they know exactly what to say to the defense. They know exactly what to say to the judge. They're like, I'm totally fair. I'm going to let the evidence decide. Doesn't matter if I'm pissed off at other companies. So yeah, that's going to work.
I wanted to ask you a question. I thought it was, you tried a case against a school district during COVID.
I was going to say LAUSD.
Right?
Yes.
Yeah. I don't think the bullying occurred like during COVID, obviously, right?
No, it was before.
You still had to deal with.
That'd be quick.
Yeah, you still had to deal with I'm assuming either teachers or principal or people that are public school employees. Was there any biases, do you feel like, against or that were in favor of, giving these people a break because teachers and COVID and all that stuff? Did that come into play at all?
Sure. I mean, there were several people that would sit on there were prospective jurors that were like, I went to LAUSD. That wasn't the school district that we were, that was part of our case, but they were always screwing things up, or they were always this, or they were always that. And so, I didn't have the background of Harry's preconditioning, but it was certainly a situation where we're trying to differentiate what their experience was with that district versus what was happening over here, without giving too much away. So there was a lot of that. There was also a lot of, look, teachers do the best they can. They can't be everywhere all the time, So fortunately, Claire actually gave me some good questions to ask some prospective jurors on protection and schools' responsibilities and how they feel that way. But yeah, that was definitely there.
Yeah, I feel like getting the school district or somebody that's a teacher on the hook, given their a job, and somebody that's been really affected by what's been going on, is probably tough. There's going to be some inherent bias towards educators even before COVID, but especially now. I feel like that's a pretty uphill battle.
Well,
I would say okay, so good.
Yeah, I was just going to say there was that, but then there was also, we had, I think we just fortunately and unfortunately at the same time, the pool that we had was a largely male dominant, early to mid 20s pool that are all sitting there like, fights happen at school. So what? That was a huge thing to overcome too. Go ahead, Claire. I'm sorry.
I have thoughts towards both of these, actually. One, I would say, as someone who has utilized the trademark Harry Plotkin prehabbing method, and I do it a lot, you have to really, if you're going to do it, first of all, you should. And second of all, you need to be all in on it. You can't do it in a half-assed way. It's kind of and I know this because I've offered the advice, it's kind of stressful, prehabbing, because then you're like, well, shoot, now I'm pointing out people who have bad opinions, and I don't, and what if the defense attorney wouldn't have noticed this otherwise? And now I'm highlighting good people. But no, if the defense attorney does it and you didn't, then they have all these things to just pick off. And you're not always going to be up against defense attorneys who don't know what they're doing in voir dire. So if you have a defense attorney who's actually good, you need to prehab. And that was one thing when I did that Lyft case against a very good defense attorney. I remember Harry told me before I left, do not let the lawyer get away without prehabbing. And I was like, I'll do my best. It was an uphill battle for sure, because people have strong feelings on rideshare services and on wrongful death.
And they know, and a good defense attorney will know, if you don't prehab, then that's a golden opportunity. They're going to I'm going to get it easily. I'm going to get off every juror who feels sympathy for someone, whether it's a kid, school bullying or whatever. Every juror who doesn't like or trust schools or Lyft or corporations, easy call. And they're going to trick the jurors. They're going to tell them, you're not allowed to feel sympathy. You have to leave it at the door, which is outside the courtroom, which is totally not true. They're allowed to feel sympathy. And sometimes they'll say, can you look? I mean, one time I even had to go as far as get lawyers to object when the defense lawyer was going, can you look the plaintiffs in the eye and send them and tell them they get nothing? And the jurors were like, we were starting to lose some. And I was like, you're telling, like, you don't have to actually tell them that. And then one of the jurors was like, oh, I don't. I thought he was telling me that that's what we had to do. So I shut that down really quick, but they do. I mean, the things that that they're going to do, because you've seen them do it a million times, you got to shut that down before it even starts. So, so important.
Another good one where I wanted to do it, but once again, time got away from us because we were given 15 minutes because it was federal. And unfortunately, unlike Bernard, I didn't have the luxury of having a bunch of questions that I was able to create beforehand. I came in last minute. So all the questions that had been submitted to the judge were submitted before I was involved, but it was an LAUSD case. And same thing, had we been able to properly prehab the 4 jurors who had very negative LAUSD experiences, I mean, those would have been there. I mean, we wouldn't have had enough strikes for them because you only have 3, but the attorney it was just hard. It was hard for her. And the time limit was too much. I think it was 10 minutes. Yeah, I think it was 10 minutes. And prehabbing takes a good amount of time, unfortunately.
I mean, it's always dangerous to not do something in hopes that you aren't going to tip the other attorney off. That's like being afraid of the dark. You got to do the best that you can when you're out there and see what the other side does. I mean, you're the plaintiff's first one that gets up, and you do all this work to get the jury all warmed up, and now they're speaking and talking, and then the next person gets up, and the jury thinks, oh, this is the way it's supposed to be, and so they're speaking and talking with them. That's just the way it works. You basically have to take your best shot.
I think the best, most successful way to do voir dire, besides obviously what Harry said, prehabbing and finding your badgers, is have a good pet question that is a litmus test for a good juror for you that is not obvious to the defense. And then, so at least once you've deselected, you might have a couple people who are like, I got some really good answers from these 3. And if the defense leaves these 3 on because they're clueless, then this is a solid jury, And obviously those questions take a lot of thinking, but for that Caltrans case, the clincher question was, who here thinks that a property manager or property owner has a duty to preempt accidents from happening on a property, look around, maintain before they happen, or should they just wait till somebody reports an accident, And all the jurors who said, no, you have a duty to prevent it ahead of time, do all the work ahead of time, those were good people. And the defense said,
if you have limited time, do you focus on the people that are the leaders, or what do you do? Because time is always the issue. I mean, you bump up into one juror and he starts eating up your time, or she, or you can't tell who they are. They keep being dodgy, and you're trying to get underneath the veneer to figure out whether to keep them or not. How do you deal with when you have a limited amount of time and you got to make progress? I try and focus on the people that I think are going to be the leaders. What do you guys suggest?
I mean, I start with shows of hands and then go from there with limited time. And I kind of assume that cause challenges are really going to be very few, right? Harry, what would you do? I didn't mean to cut you off.
With a limited amount of time? I mean, if you have a really limited amount of time or you're running out of time and you feel like you haven't heard from everybody, for sure. Yeah, I would say, if I was writing a note and the judge is 5 minutes or 10 minutes or something, I'm writing a note to the lawyer I'm working with and saying, ask this one question and ask it to these 4 jurors, because those are the ones that I'm not sure about. Either I haven't heard enough from them, and I think that they're leaders. I mean, I think a juror is going to be quiet. I'm not even going to bother. But yeah, so it's certainly here are the ones that I think are going to be really strong jurors one way or the other. I need to know more about them. If it's someone I already know enough about that I have a good read on them, not necessarily, but yeah, somebody who is a leader, who's going to be a really forceful juror, and you need to be more sure of them than anybody else, for sure.
Yeah, if you were sitting there and you have a few minutes left and you have a CEO of a tech company and a vice president of a bank, I need to hear from them. I mean, I guess I could assume they stink, but I'd rather talk to them first because they could also be a really good juror because and really forceful one.
And that's the thing is that's a great point, Claire, that, we only have 6 strikes, and you really don't have the luxury of using a lot of the strikes on people that you just have a good bad vibe from the surface of. You're like, well, that guy's a CFO. I'm definitely striking him. Okay, one of your strikes is out the door, and that might have been a great juror for you. Now, it may be that 80% of CFOs, white CFOs work for the big corporation or whatever that person is, are bad for you. But 1 time out of 5, you just struck your best juror over there. So make sure. I mean, you always want to make sure. And I think even awful answer.
And I would add to that, a defense attorney usually cannot bring themselves to strike an old white dude. So if you have a good old white dude, they'll probably stay on. I mean, it's the truth.
Oh, yeah.
Don't tell our secrets.
We actually had one in the trial in October in Van Nuys, and he was an accountant. And so we were kind of worried about him at first, as far as it came to calculating, non-economic damages, right? And he was also a very strong personality and an old white dude. And so this particular judge allowed the jurors to ask questions. And he had a question for every witness. And it was a total roller coaster because some days or some witnesses, he had really good questions. Other witnesses were like, oh, we lost it. It was such a roller coaster, but he ended up being a great juror for us.
Yeah. Yep. Seeing in that Caltrans case, I really thought this one juror he kept me up at night after I picked the jury. His answers were all great, but he was like 50-year-old white property manager from Manhattan Beach who was willing to drive every day to Burbank, which I thought was like shocking. But yeah, former property manager, now tech recruiter. And I thought, oh God, but his answers were so good. And he was the foreperson and he was amazing.
Yeah. See, I never lose sleep about those types of people. I'm like an NBA player who's like, 0 for 10 shooting threes and I'm still shooting. I mean, I'm not worried about if there's somebody who seems like a bad profile, or somebody that the lawyer I'm working with is like, hey, that person just really makes me nervous. And I'm like, I love that their answers. We're going with them. I don't worry at all. The answers that they give are so much more important than what they look like at the surface. And so, don't be afraid to keep somebody who fits an engineer or, CFO or landlord or whatever, or property manager. If they give great answers that they're like empathetic and have high standards and are very critical of corporations or defendants or whatever it is, then go for it. Keep them and don't be worried about it.
Yeah.
Well,
sorry, go ahead.
I was going to say, you don't know how many times the HR person, nice African-American woman, she's sitting there, she's looking at you and she's smiling and she's happy to see you there. And then you find out she used to be an HR manager and there's virtually nothing you can say that's going to convince her that the HR department did anything wrong. Oh yeah, that investigation was just fine. They only spoke to a few people, but how many people do you have to speak to in order to get So you cannot judge people by their race or their job or that. You really got to get them to hear them speak, hear them say something, because that's when you find out who they really are, right?
Bernard, what you say is an excellent point because I did tell you I don't like smirking, but I do think that a lot of lawyers get really false positives by smiling. Just because a juror is laughing at your jokes in voir dire. And that's why, I know a lot of lawyers love to just be really personable in voir dire, but it's not enough. Okay? Like you're hearing this from me now. Being personable in voir dire is not enough. They can laugh at your jokes and still defense you. Okay? No, it's not. Actually, there's so many. I think Bob totally knows. Bob's very aware that there are bad jurors out there. But a lot of lawyers think that's all they need is a shtick, and it's not enough.
I have to, unfortunately, call it a day. But before I break, initially this was going to be a post-COVID, COVID juror. But I'm very glad it kind of turned into just kind of a broad scope of this is tactics and everything. It's great. This was a podcast where I'm usually prodding people and asking them questions, and you guys just kind of talked and did your thing, and it was great. I prefer it to be that way. So it was awesome. Really informative. And it was, I hope our viewers kind of will take a listen and take the time to listen to all of it because it was really great. So before we break, I know all of you are still in the courtroom and still trying cases. COVID's still going to be around probably through this year, and there's still going to be some masks and rolling restrictions. Where do you see it? Where do you see our juror pool being in the next year or so? Are things going to go back to how they used to be? Are people going to go back to being grumpy and forget that COVID ever happened and not, start taking advantage of all the stuff that they didn't take advantage of? So what do you see trends, and how are people going to be reacting in the next, once this thing is over, if it's over?
I think there's a certain demographic that is going to be better. I don't know about anybody else, but I've been really saddened to see a bunch of moms leave jury duty because of having to watch their kids at home, or teachers. I've lost a lot of teachers because they have not been in their classroom and they feel for their kids. And I like teachers often, so I'd be happy to see those people be willing to serve again. So, I would like for that to get better. I think it will.
Yeah, I couldn't agree with you more, especially moms and parents. That was a hard thing about the case against the school, because we wanted parents that are sending their kids to school to want to be there and to want to protect our client. But they couldn't be there because they had their own kids at home that they were worried about and that they needed to take care of. So I agree with you. I hope that demographic comes back.
Well, I think jurors are more thoughtful right now, and that is the key. And I hope the thoughtfulness does not go away. I think part of the polarization, the Black Lives Matters, the people being at home, all those things were kind of a good mix to get people to be more thoughtful and willing to speak up and say something. And so when they've gotten into the courtroom, they've been willing to speak up, take a stand. That's the impression that I've gotten, and I'm hoping that people. That part of people won't go away.
Yeah. More thoughtful and more informed, don't you think?
Yeah.
Yes.
Yeah. And I think, I would be more concerned if I thought that corporations and defendants and defense lawyers learned something from what's going on right now and were more responsible, and then that caused the tide to turn. But, I'm not going to bet on that. I think that people have had their eyes open, and I don't think that they're going to, defendants and defense lawyers and corporations are going to be able to change the tide and get people trusting them anytime soon. And so, but for the time being, for the next couple of years, I think, let's get a lot of huge verdicts and at least make it worth our while before jurors start realizing, gosh, there's a lot of big verdicts out there.
They try to change the law and try to hamper what we can do and try to cap our fees and try to make access to good attorneys more difficult. So instead of adapting with the times, they're just going to try to, we'll change the playing field a little bit. That's interesting.
Yeah, it seems like they're just doubling down a little bit, which that's fine. But I was just like focus grouping a case last weekend in a rural part of Missouri, and you'd think like, oh, maybe some people listening are like, these guys are just LA lawyers and liberal LA, and of course those jurors are all anti-corporation. Those jurors out there were hating on the company just as much, and they were complaining about like this company, is the same thing Tesla did in that case. They were like, this company set up all these layers to distance themselves from liability. And that's a bunch of bullshit. And this is a company that, hired an independent contractor and claimed that, we distance themselves. So, I think it's happening everywhere. So it's not just an LA thing. So
1 minute away from an hour. So this is officially the longest podcast we've ever done. So congratulations. And it wasn't boring. Usually, it gets past 50 minutes. I'm like, all right, we got to wrap it up. But that was, he kept it interesting the whole time, and we could have gone another hour. Honestly, that was awesome. So thank you guys so much for coming, and keep going out and getting jury verdicts and picking juries and kicking ass. So thank you so much for joining the podcast, and thank you so much.
Just a quick question for Harry: what's beyond Armageddon verdicts?
Oh, that's a good question. What are they going to call the billion ones? What's... I
got to have hope. I don't want to think that I peaked too soon.
That's like end of the world. Armageddon already is the end of the world. Afterlife verdicts, I have no idea what that means.
Right. Next topic with Harry.
It's like putting these companies out of business.
Yeah.
How to get higher than Armageddon.
Thank you guys so much.
We'll do that next.